Good morning, Your Honors. Michael Monteverdi on behalf of American Capital. You're on mute, Your Honor.
You're free to start.
Okay. Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Sure.
Good morning, Your Honors. This is an appeal from an interlocutory order compelling two parties in a property insurance dispute and a commercial condominium association to the appraisal process. I want to start off at the outset because I think recently there have been a number of appraisal cases that have moved through the courts. I want to start off at the outset by indicating that this is not an inflated claim case. And I say that kind of in quotes because there have been 2 or 3 cases that have gone through this court that have been deemed somewhat inflated or exaggerated claims cases. That's not what this is. And I'll address that a little bit more later in my argument, but I wanted to kind of make that clear at the outset. The appraisal law currently is somewhat in flux, and the Leeward Bay opinion has in many ways started to change the landscape, or at least seemingly change the landscape from what I think everybody believed it to be. Whether it was or it was not, the general consensus at all times has always been that when a claim is wholly denied, appraisal is inappropriate, and that it is not something that is available to either of the parties. And the Leeward Bay decision kind of turned that on its head a little bit under some limited circumstances that we think are distinguishable here. And even to the extent that maybe American Capital doesn't necessarily even wholeheartedly agree with where Leeward Bay got, and I'll talk about that in a moment. No court prior to that decision had ever determined that a claim that was wholly denied could be subject to the appraisal process. And that goes all the way back to Johnson v. Nationwide, State Farm Lycia, and even the San Sebastian case that was dealing with an arbitration matter. And what the Leeward Bay opinion talks about is it says that, well, Johnson never actually made the statement that you couldn't send the claim to appraisal just because the issue was solely an issue of coverage. And in fact, that court never said that that wasn't a possibility. It didn't say that you couldn't send a claim to appraisal to determine amount of loss before coverage was determined. It just simply said that coverage issues in a wholly denied claim had to be determined by the judiciary, and that amount of loss issues then could be determined by an appraisal panel. We think that that may be a little bit of somewhat of a misapprehension of the case on Johnson, because what Johnson did was Johnson ultimately was determining a circuit split between the 3rd DCA and the 2nd DCA as it relates to the Gonzalez case and the Johnson case. And in both of those cases, the claims were submitted to the appraisal process despite there being a wholly denied claim. And what the 3rd DCA and Gonzalez indicated in its opinion was that because the claim was wholly denied, what the Supreme Court had initially said in State Farm v. Lycia regarding appraisers being able to make a determination as to causation did not apply. They could not do that under the confines of a case or in the context of a case where the issue of coverage as a whole was being determined. And ultimately, the Johnson court affirmed Gonzalez and agreed with the 3rd DCA and indicated that these coverage issues are issues that are solely reserved for the court, and they are not something that can be determined by the appraisal process. What was also interesting is in the Leeward Bay decision, and I'm addressing this head on because I think that this is something that's going to be raised by the appellee, is that the Leeward Bay decision also didn't look at the contract. And the insurance contract is very, very clear that appraisal and mediation are both available to either party if they demand them when there is an amount of loss dispute. But the case law in Florida is very, very clear. You can never have an amount of loss dispute unless you know that there's a coverage issue. And the sole dispute here is an issue of coverage, whether or not the claim is covered. And that was raised before the Leeward Bay decision was ever issued. In fact, my argument to the trial court, where we started off and said, the issue here is not an issue of an exaggerated claim. The issue here is an issue of misrepresentation and fraud that goes well beyond exaggerated claim. Now, does this claim involve an exaggeration as to the amount? It certainly does.
Well, let me ask you, Mr. Monteverdi, do you see a distinction between 2 cases, the first of which being an insurance company denies coverage outright for base, the insured did not comply with the policy, whatever it is. And the second case where the insurer initially says, you've got coverage, I'm going to go ahead and make I'll send you initial payment. And then later the insurer determines, gee, they weren't truthful to us, they're hiding stuff, they're doing all kinds of stuff, we've changed our mind. Should those two cases be treated differently? Are they the same? Does it matter? And I guess my question is, does it matter when in the process the insurer takes the position there's no coverage?
I think the Southern District of Florida addressed that very, very issue. And I know that the federal decisions are not binding on this court, but in the Treasure
we
K
listen
case,
to them.
and in the, fair enough. And in the Treasure K case, that issue actually came up. And the issue that was raised by the insured in that case was the very one that Your Honor just raised, which was, they said, basically, we think the insurance company here is retaliating against us after suit has been filed by denying the claim for misrepresentation and concealment. And what the Southern District of Florida said in that case was, they said, there's no case law to suggest that there's a timing requirement for denying a claim if it is done validly. And actually what it ultimately goes to, that question will go to the strength of the coverage defense. And that's something that ultimately will be hashed out in the trial on the merits in the plenary trial to the jury. And so they've actually addressed that head on. And there's a reason, and off the top of my head, I don't remember which case. It's one of the cases we cited. I believe it may be Taylor v. State Farm. But one of the statements is that misrepresentation, fraud, and concealment are self-concealing by their nature. That's what they do. They are meant to hide things. They are meant to conceal things. They are meant to make it so that you can't find it. And to have a standard, which is, well, if you don't find it till later, then all of a sudden your posture changes and you are no longer have a right to the available remedies because you found it later because the other party was successful in their misrepresentation or concealment, would ultimately belie the reason for why those provisions exist in the policy, which is they are something that the insurance carrier is able to rely on. And what ends up happening in these circumstances is that we end up in a place in the federal district courts in Garden Villas, Oceana 1, Treasure K, they address this exact issue that's before the court today. And in all of those cases, they said you have to go deal with the issue of misrepresentation and concealment and fraud first. Then you can send it to appraisal. And there's a logical reason for that. The logical reason for that is that if you don't do it that way, what ends up happening is you end up in a circular place. And I understand the Leeward Bay opinion, and even more recently, the Villaggio opinion are a little bit different because in those cases, the underlying insurer said during the course of the underlying case, our issue here is an amount of loss issue. We think they've inflated the claim. They don't think they have. That is our issue. That's a misrepresentation. And what the Leeward Bay court, or what this court said in Leeward Bay is, you've basically admitted that we're talking about amount of loss. And because we're talking about amount of loss, the appraisal process is the proper venue to make that determination.
In this case we have in front of us today, there is a dispute of the amount of loss, but the underlying facts are concerning. The claim has been made for roofing replacement that's 2 or 3 times the price that the actual roofs were replaced for. Yet the claim is still being advanced, seeking the bigger number. Is that right? Isn't that kind of the cornerstone factual scenario here?
That is correct, Your Honor. And what's even more troubling is that during the course of the claim, when documentation was requested,
it wasn't given right away, and later you found it. Yeah.
Later found it.
Here's the thing I'm having trouble with, though. It sounds like we're going to get into a factual nightmare with these cases. When is it an amount of loss dispute, and when is it basically a fraud or misrepresentation? Because it becomes real shades of gray. Because what the courts have become concerned about is that insurance companies unilaterally claim it's a no coverage case and avoid the appraisal process on a sliding scale of facts. So how are we going to draw this line? Are we going to draw the line? And if so, what's going to make us draw the line? Where do we draw the line with this?
Sure. Well, I would first say I think this case is on the other side of the line, but I would say that the line.
Well, I would have expected you to say nothing else.
But But I think that in general, I think the line comes down to the issue of whether or not a coverage determination of no coverage is made. And I would say this, neither party to this contract has an absolute right to appraisal. They have a right to appraisal when there is a dispute as to the amount of loss. That is clear. If the insurance carrier or the insured decides that the issue that they have is a dispute as to something other than the amount of loss, or I guess the dispute as to coverage, then ultimately they do have that right to say, this is our dispute. This is our good faith dispute. We are making this dispute. These are the facts that we are using. And if that's the case, and they wholly deny the claim, that claim, at least from a fraud perspective or misrepresentation perspective, has to be litigated first before appraisal. And I'll explain why, because there's a very good logic behind it. And it's really, I think, the underpinning of the case law, why we get there, but I think it's also just very, very logical and rational. What the Leeward Bay opinion says is it says, look, because the issue that we are alleging as misrepresentation is one of a determination of amount, the appraisal panel can determine the amount. And if the appraisal panel determines that the amount is something that is similar to what the insured claimed, then we do not have a misrepresentation. They can make that determination, but there's an issue there. Because if the underlying appraisal is itself beset by misrepresentation and it's founded on a misrepresentation or concealment, the appraisal panel is not equipped to deal with that. That needs to be dealt with by way of cross-examination of witnesses, discovery, trying it to a jury, evidentiary.
Well, isn't the appraisal panel just going to fix a loss? They're not going to delve into these things that we all agree is a call for a court to make.
Of course, and I think that's the issue. Because I think the ultimate issue is that if the appraisal process itself is founded or premised on an issue of misrepresentation or concealment, then what ends up happening is under Leeward Bay, what you would have is you'd have a demand for appraisal. Carrier says that it's based on misrepresentation or concealment, goes to appraisal panel can't make those determinations as the misrepresentation or concealment, may issue an award that's higher than it would had that issue been resolved first. And then that award is used in a circular fashion to demonstrate that there was no misrepresentation. So the actual misrepresentation itself ends up proving that it doesn't exist, which I think is a little bit of an issue there. And so and I think that if you go back to Lycia and Johnson, they say something very, very interesting. They say that when a demand for appraisal is made and when it's determined that appraisal is appropriate, an insurance carrier only has really two main defenses. It's really one defense and then a basket of defenses. It's coverage as a whole, and the courts have kind of dealt with that in the Kennedy decision and dual tracks, but it's coverage as a whole, or as they say, common policy conditions such as fraud, late notice, and lack of cooperation. Well, that's exactly where we are here. Fraud, misrepresentation, and concealment. It's one of the things that has been contemplated by the courts from the very, very beginning as something that is a condition preceding to going to appraisal. These issues have to be resolved. And when you start taking these cases, the appraisal cases, and then you start looking at them through the lens of Wong Ken, Schneer, Flores, all cited within the briefs, dealing with misrepresentation, concealment, and fraud, those cases all say that once there's a misrepresentation as to one part of the claim, the entire claim is voided. The coverage is voided, it's gone, and it's because you cannot allow a party to benefit from its own misrepresentation and concealment. And actually in Flores, one of the arguments that was made was, well, wait a second. The misrepresentation we made was very, very small. It was some PIP submissions that we made. We changed one from $5 to $30. We changed one from $30 to $130. In the greater scheme of the claim, it wasn't that big of a deal. And what the court said there is they said, well, that argument that's being made is you shouldn't punish us for small fraud. They said, but if you don't punish them for small fraud, the reverse is then true, which is then you allow somebody to benefit from small fraud. And what we're saying here is we're saying, look, at the end of the day, if this case goes to a trial and is litigated on the issue of misrepresentation and concealment, and American Capital loses, then the case would be ripe for appraisal. There's no question, because there are no other causation defenses that are being claimed insofar as it is consistent with the case law. I think the case law, even the federal case law, says it's not that the insured doesn't have the right to go to appraisal. That is not what the case law says. I actually think it should say that, but it doesn't. What the case law says is that once the issue of fraud and misrepresentation and concealment is determined, if it's determined in favor of the insured, then that case is properly set to go to the appraisal process. And it kind of circles back to what I was talking about earlier, which is that makes sense because now you have a judicial determination that there is no misrepresentation or concealment. And therefore, you can be confident that the appraisal process itself is not premised and founded on an underlying misrepresentation or fraud. So when you take the case law, starting with Johnson v. Nationwide, and you start working through the cases that have addressed this very issue, they all come to the same conclusion, which is these issues of misrepresentation or concealment are preconditions to appraisal. You have to have them determined first. And it's the only way you're going to get a fair and equitable determination in the appraisal process. I think that, and why I started off the argument by saying that this is not an inflated claim case, is I do think that there can be an argument made. I don't necessarily agree with it, but I think that there can be an argument made that says if the only issue that exists is that the amount of the claim is somehow inflated, maybe that is something that an appraisal panel can determine, since they have been deemed by the courts over time to be particularly equipped to deal with amount of loss issues. And I would,
Mr.
sorry,
Monteverde,
You understand part of the confusion with this is many times an insurer will label an inflated claim case a fraud case.
well, I
Right?
think
All they got to do is throw the word fraud in there because they're giving us a number that's too big, their estimates are fraudulent or whatever it is. And that's why we're in this situation, because insurers have been too quick to throw fraud out there when they get a number they don't like.
I don't necessarily disagree with what you're saying, Your Honor, but the only thing I would say there is, again, I would kind of harken back to what I said earlier about the issue of the policy itself. The policy is an agreement. I don't think anybody can say, looking at the policy provisions, that the two parties agreed that they would appraise issues of misrepresentation and concealment. Right? We've gone very, very far from what these policy provisions were actually agreements on. They were agreements to, if we both agreed that there's a covered loss, but we can't figure out what the amount is, we'll send it to an appraisal panel to make that determination, to save costs and judicial resources and time, and we'll send it to a panel to have that panel determine it.
Mr. Monteverde, you are into your rebuttal time. Do with it what you want.
Okay, I will finish this statement and then I'll conclude and save the rebuttal. No, and so I think that at the end of the day, what ends up happening is the appraisal panel now has been moved into places of causation, and now are even being moved into circumstances where they're being asked to make determinations as to whether or not an inflated claim is fraudulent or not. And we just believe that that's something that should be reserved to the judiciary and to the jury. I will reserve the rest of my time. Thank you, Your Honor.
Sure. Thanks. Sorry about that. I had a equipment failure here. Okay. Mr. Goggin.
May it please the court, Kerry Goggin on behalf of Palmetto Dunes. Today, there are two primary issues or two primary themes that I think bear addressing. So this is obviously a changing landscape in the wake of Leeward, Cayman, and Bellagio that this court decided. And I think underpinning those and underpinning the Johnson decision before it, as well as the progeny leading us to where we are today, the two concepts that are being given effect are, number one, the right of the parties to contract and to trust that contract will be upheld. And the second, which I'll be addressing, is really the right of the trial court to not only control its docket, but to control this process of appraisal, because, and I will argue that it's best positioned to do so. So first, as it pertains to the contract, ultimately, the policy is entered into by both parties where there is an appraisal provision. In this case, it's a unilaterally elected appraisal provision, should either party prefer, where there is a dispute as to amount. One may elect the appraisal provision, and this proceeds from, let's say, the trial court into the appraisal process. So it's worth noting, because I think it addresses a number of these concerns, that the appraisal process is somewhat limited in what it does. We're all in agreement that coverage is a judicial determination. That's reserved to the courts. What appraisal does in the timeline of, let's say, a lawsuit, we move along, we invoke appraisal or the trial court orders to appraisal. We simply excise a certain portion of that case. And it's a limited portion. It's a very limited portion. I think this reconciles a lot of things. This is simply the amount of the loss. This goes over to what the parties have agreed to be a panel of professionals, to appraisers and umpire to determine. They then, after this processing, simply reinsert the product of their processing, i.e. this amount of loss. And then the court picks up from there to determine the issues of coverage, whether that be fraud, concealment, lack of payment, or so on and so forth. And I'll distinguish those a bit in a moment. But ultimately,
But Mr. Gogan, you've heard Mr. Monteverde say that he thinks it should happen the other way around.
Yes, Your Honor.
What's the harm in that?
Well, Your Honor, I think you're effectively depriving, in this case, the insured of a contract right. If we consider what would have to happen, ultimately, because I think even as Mr. Monteverdi acknowledged, there's not just this issue of concealment that's being brought up. And of course, we hotly contest whether anything here has been concealed. But if we talk about not just the issue of concealment, but every other defense, and I don't remember the precise number, but there are a good number of affirmative defenses and even a counterclaim. All of this would have to be determined at trial, including the amount of loss, the causation, and all of these things that the contract suggests needs to be addressed by the appraisal panel. So by the time we go through a, let's say, and this sort of pulls in elements of judicial economy, by the time we go through a 3-week trial to prove not just, concealment, but to prove misrepresentation, which necessarily determines or requires the determination of an amount.
We have bifurcated trials all the time.
Yes, Your Honor. But nonetheless, I think at this point, to only attempt to determine every defense prior to appraisal would effectively limit the ability of this claim, because I guess the argument is you can't possibly determine every defense, which I think is perhaps Mr. Monteverdi's argument, without also determining, because all of those defenses theoretically void coverage, without also determining the amount of the loss. And I think having a jury determine amount of loss to, let's say, determine inflation or misrepresentation or fraud or whatever it may be, in the instance of some of these aspects of their defenses, would simply, why would you go to appraisal after that? I think that sort of flips this idea of judicial economy on its head, and also has the effect of depriving, again, in this case, the insured of its contractual right to have this appraised. I note that this is a contract because this is simply, very, very simply remedied. Change the contract. I think in this case, it's in the contract. A lot of these problems could be avoided by having a mutual consent contract, by simply outlining in that contract a good number of other prerequisites, conditions, or whatever it may have been. But ultimately, I think the answer, this kind of jumps ahead into my other argument, is trial court discretion. I think the trial court is really best positioned to determine whether or not a case is positioned to go into appraisal, whether a bifurcated trial is appropriate, whether, and again, I would disagree with having an appraisal after a trial, just again, for instances of judicial economy and the fact that you're having judge or jury determine amount rather than appraisal panel as contracted. But this, and I think this is what the Leeward, Bellagio, and Cayman decisions sort of implicitly acknowledge, and to some degree explicitly, this trial court can determine if the case is appropriate, if the issues in this case are appropriate, to have at least a portion excised, as I've said, and put into the appraisal process for, later reversion back to the court and determination of ultimate coverage. So at this point, I think it's worth addressing this idea of coverage, because this is another conclusion or another finding that was inherent in Johnson. This was articulated in the Island Shores, which is a federal decision, which basically directly contradicted the Oceania. And it's also acknowledged in the Leeward and Bellagio decisions. Coverage can be, quote unquote, admitted. So in Johnson and Leeward, Bellagio, and Cayman, what had happened to admit coverage, so to speak, was obviously that they had paid. All of these are Hurricane Irma claims. These are all damages claims for roofs, windows, other things. And in each case, the insurer had not only gone out and adjusted the claim, found that there was an amount due, but in each of these had actually paid the claim as well. So what I think—
we have that here, but we have these very egregious facts here.
Well, Your Honor, I don't think—
Well, go ahead.
I apologize, Your Honor. So number one, I think those facts are the appropriate domain for a judge or jury to determine down the road. Number one, I would say the egregious facts are not nearly half as egregious as I think the opposing side has stated. Okay.
Well, I mean, it's not a complex factual scenario. It is, we're claiming, I think, $7 million for roofs that we've already put on for 2.5 or numbers like that.
Well,
and by the way, when you asked for the documents about our roofs, we didn't give them to you. And later they found them, digging through, other records. So that's pretty egregious.
Your Honor, I would have to disagree because there are two things that sort of underpin the opposing side's argument, which I don't think are fully appreciated, or maybe we haven't fully articulated what happens. So number one, the amount. This amount was conveyed via sworn proof of loss. The sworn proof of loss is one of those post-loss obligations that has been articulated under the policy, but the sworn proof of loss is an inherently, I will say, at least limited procedure. The insured requests a sworn proof of loss, tell us the amount you're demanding from the insured. The insured then has to reply within so many days. That's what's happened here. The problem is it's not inherently a full statement of the claim for hereafter and evermore. It's a snapshot of the claim at that time.
But they were asked to reaffirm that that was their claim under oath, and they said, yeah, that's what we've been told to ask for.
My understanding at that point was that the roofs had not been replaced. I think this is pertaining to the examination under oath of Mr. Brennan. And ultimately, while there were estimates, and this is sort of what I'm getting at with the sworn proof of loss, as these claims, I guess, get into the months and years, things change. Prices change, the ability to get bids. In this case, the necessity to replace the roofs. The mitigation efforts alone were not sufficing for this particular association. And ultimately, they progressed from having an estimate from Katerra, a general contractor, which had quoted this very generally at, I believe the number is $7 million, to getting specific estimates from, I believe, Colonial, I think Advanced, and another roofing company, all of which were lower. But they're also separated in time. The sworn proof of loss in this particular instance was submitted, I believe, April of 2019. And ultimately, this EUO is in July, and in the interim of 2019 as well. And I believe in the interim, they end up getting a number of estimates that show, in fact, that there is a lower price. These are also because these are from roofers directly rather than simply a general contractor who may have added their own markup. Insofar as the documents are concerned, again, I know it's contended by American Capital. These were produced 2 years after the fact. This is, again, a document request subject, which arises under the policy. They're provided when requested. And again, I think the complaint here is they're concealed by being provided as part of this voluminous production. Well, the insured asks for all of these documents. We provide all of the documents. I think it's a potentially dangerous precedent to start saying that the insured has to really differentiate, well, which are we going to put at the top, which are we going to put at the bottom? Truthfully, I have no idea where in the document production they were, but assuming they were in the middle, I don't see why that would be any different, because were we to put them at the top, then by God, we would be concealing something that we chose to place in the middle. So I think in both of these instances, there really isn't concealment. There was a request from the insured to provide documents. We ultimately provided those documents. I think the fact that they, didn't break into a storeroom or something of that nature and discover them, despite the fact that we were trying to shred them or something of that nature, suggests that we were in fact complying with the post-loss obligations.
Mr. Goggin, we spent a lot of time talking about the fraud and the events, and those are all factual issues. Was there any question here that there was a loss that was admitted by American?
No, I don't think there is a question that the loss is admitted. I think the issue here, if we're looking at admission of coverage in the way that Johnson frames it and the way that Leeward and Bellagio frame it, the admission comes from acknowledging that the cause of loss, the hurricane, is covered by the policy, that the property or the subject of the policy is covered by the policy, and that these two things basically exist such that coverage in the general sense, i.e. does this policy apply to these facts, exists. Here, again, I think American Capital would acknowledge that they determine the amount of loss, again, necessitating a determination that both the property and the hurricane are covered. They made that determination in the amount of $500,000. After deductible, they actually paid out an amount of $100,000, just over. Those are approximate numbers. So in this case, it is absolutely admitted that there is coverage. Okay, I think this discussion of this other use of coverage, i.e., will the insurer ultimately have to pay, dovetails with this concept of void, and it really, at the heart of it, gets to what Johnson and by extension Leeward in these other cases term defenses. These are defenses for a jury to determine. So all of these facts we've been discussing for the last 5 minutes are ultimately things for a jury to consider and weigh. So if we go to appraisal right now, the appraisal panel will say, okay, it's $500,000 loss, it's a $25 million loss, or somewhere in between. They will then just simply pass this over to the jury. The jury will consider how we produce the documents, whether we should have ordered them, whether putting documents in the middle of a document production was acceptable or not, and they will determine whether those defenses are applicable, such that the coverage, in a way that I believe AMCAP is using it, i.e. will I absolutely have to pay, could be zero. So the payment could be zero if these defenses are ultimately upheld. But the coverage, i.e. does my policy apply to these circumstances, loss, and, well, type of loss and property loss, is admitted by the fact that necessarily when an insurance company pays, they have to concede that, yes, that type of loss, hurricane, and the property, in this case, Palmetto Dunes, is covered by that policy. This is what brings us into that realm of contract. Once we understand that the facts of the case, hurricane, insured property, are acceptable, we understand, or covered under the policy, we understand that we are within this contract, and therefore appraisal may be appropriate, again, pending further determination by the trial court. This would differentiate itself from a lack of coverage as a whole, which is also discussed in a number of these other cases. A lack of coverage as a whole, as I see it under these definitions, would be something more along the lines of you've insured your primary residence, but not your guest house. There is no coverage for the guest house, so if it was damaged, there is no coverage, ergo appraisal is inappropriate. Or cause of loss. You have insured your property against fire, but you've not insured it against flood. There is no coverage for flood, ergo appraisal is inappropriate. However, where we have at a bare minimum, and I think the trial court could make this determination as well, but at a bare minimum here, conceded that both the type of loss and the property subject to this claim are covered by the policy, and appraisal would be at least generally appropriate. Again, generally appropriate for the trial court's determination and discretion. So ultimately, I guess at this point, Leeward has articulated a minimal standard of ripeness as a threshold for the trial court to determine whether or not appraisal should go forward. So this involves three factors that are really not contested here. That post-loss obligations have been complete and that a reasonable opportunity to investigate has been had. In this case, I'm not sure there's that contention, but I will say that even the underlying proceeding was stayed for a period of time to complete whatever else American Capital wanted to complete in terms of post-loss obligation and investigation, and that there's ultimately a disagreement regarding value. I don't think, again, that's even remotely contested in this case. Once those things occur, even if we set aside generally a threshold appraisable issue by admission of coverage being the application of the policy to the facts at hand, more broadly, I think the trial court has discretion whether to send it to appraisal now, whether to not send it to appraisal at all, whether to send it arguably to appraisal after trial or after a partial or bifurcated trial. And it's really this acknowledgement that the trial court is in the best seat to handle these claims that I think we are able to resolve a number of these factual issues. The defenses, as Johnson articulates them, the defense of concealment, which I will note, it is fraud, misrepresentation, and concealment, or concealment, misrepresentation, and fraud in the policy. So to the extent I think it was argued that, well, no, Leeward was different, it was an inflation claim. No, this is the same portion of the policy. It is a defense, and ultimately it is something that will be heard by the court, by the jury, and I think subsequent to appraisal. Both of those cases as well, American Capital used the same terminology, that the claim or coverage was void, that it was wholly denied, and so on and so forth. But of course, the trial court in all of these instances has decided, with the exception of Bellagio, where I think the facts of that case saw that the trial court was wrong, but the trial court used its discretion to order these cases to appraisal, seeing fit, presumably seeing fit to do so. I think one of the issues of really considering these potential defenses, these policy defenses, whether they arise under policy logic, whatever it may be, a little bit too carefully at this stage, is that ultimately it's going to deprive, again, one of the insured of the contractual protections that it has, and it's going to deprive the jury of its ability to decide. But ultimately, it really just guts the contract. I guess there's no real better way to say it, because, and I think this may have been touched on before, the insurer basically has the sole discretion to sit here and say, as happened here, I don't like this. I disagree as to something. I disagree as to the amount. I disagree as to the way that you produced your documents. I disagree as to whatever it may be. And by pronouncing these words, your policy is void. That's not proven. So as we sit here today, the concealment issue, for instance, as is relevant here, is not proven. Nothing's been determined to actually have been concealed. And it's not certain, I would argue, that it won't happen. A jury has not, and a judge has not seen fit to say that, there is some issue here that would cause American Capital not to have to pay this claim. So what we're really looking at is simply the uttering of more or less magical words. I hereby void your policy. And all of a sudden, I, as the insurer, get to, for whatever reason, and again, that's a question I think needs to be asked. Why would we want to avoid a more judicially economical, procedure rather than have a 3-week trial? Why not have an appraisal and a summary judgment, or a 2-day trial, or whatever it may be? But I get to avoid this entirely simply by the words that I utter, which are unproven. So I think in its worst aspect, this is effectively making, if not the contract as a whole, at least a portion, very much akin to an illusory contract. If I make a promise to you, when you say you want to go to appraisal and we generally have a dispute, we, in essence, shall proceed to appraisal, except when I disagree. And of course, I think as noted before, insurers tend to disagree very often, and they tend to want to preserve their defenses and so on and so forth. In this case, and based on a reservation of rights, based on the case law as well, these defenses are all reserved. I think promoting the trial court's discretion to process the facts and to ultimately order parties to appraise in this judicially economical procedure is really the right way to handle all of these facts, because not only are they best positioned to see the case in its entirety at that point, but because it prevents an insurer from simply uttering something unproven, with which the insured might entirely disagree, and creating, even if not an impossibility of proceeding to appraisal and thereby entirely denying that right, then at least a severe difficulty of having to proceed through a trial, which would have to address a number of these defenses, if not all of them, and I would contend probably all of them, over the course of weeks and at great expense, to then proceed to appraisal and redo it. Once you have a jury verdict that says, for instance, a claim is $10 million, how are you going to go into appraisal and want to do that all again? So I think ultimately the two items that we talked about that need to be protected, and I think which have been done in Leeward, Cayman, and Bellagio, are, number one, acknowledging that this is a contract, again, could have been easily changed, but under this contract, the insured has a right to this process. And second, that the trial court is best positioned and has the authority to determine to send the parties to appraisal. So for those reasons, we would ask that the trial court's order be affirmed, and I will rest.
Thank you, Mr. Goggin. Mr. Monteverdi?
Sure, Your Honor, is there any way you can tell me how much time I have left?
Give me 5.
Okay, thank you. There was a statement made about magical words. There's also magical words that can also stop an appraisal, which is, we deny your claim at the outset. Your claim is denied. Those are magical words if we're going to follow that line of reasoning. There are words and there are positions that an insurance carrier can take to stop appraisal. And why? Because appraisal is an agreement that they've reached under certain conditions and under certain scenarios. And the scenario is that there's an agreement that there's coverage. The issue of whether there was an agreed upon coverage here goes back to the self-concealing nature of misrepresentation and concealment. Yes, American Capital did initially go out and determine there was $500,000 of covered damage, issued a payment of $102,000. After it determined that there was a misrepresentation and concealment of documents and information related to how the roofs were going to be replaced, it issued a letter on September 19, 2019, saying the entire coverage is void and demanding its money back. Another distinction between Bellagio and Leeward Bay. The money was asked for back. It wasn't, we're just denying it going forward. It's, we are denying the entire thing. You owe us our money back because you made this misrepresentation and concealment. The order of how this happened also is not exactly accurate in the way that it was just relayed to the court by the appellee. The roof bids were received in 2018. The 3 roof bids for about $3 million to $3.5 million. The sworn proof of loss was submitted in February of 2019. The EUO was in July of 2019. And then the roof was replaced for actually less than those original 2018 bids in 2020. So what ended up happening, this wasn't a situation of changing roof prices that changed it. What it was ultimately replaced for on a general contractor basis was almost identical to what it was bid for by that same company. The actual roofer did it for less than what they originally bid. So the price actually went down. So it's not a situation of where this Katerra estimate was first in line and was higher because prices were different. And then as time went down, the prices went down. That's not what happened at all. The policy was void, or the coverage was void. The money was demanded back. The QBE line of cases that are cited in our brief are exactly in line. In fact, I'll read from the Garden Villas case, Judge Demetrioulas. QBE is not denying that it initially estimated plaintiffs' covered losses. QBE admits that it did find a small degree of covered losses. However, what is important is that QBE has fully denied plaintiffs' claim for failure to comply with conditions precedent and/or fraud. When a claim is completely denied, it does not matter if there have been prior payments or valuations. They make that determination. Oceana One makes the same determination. State Farm v. Wingate determined that if there's an issue of misrepresentation or fraud as to a fire loss, appraisal is not available. The Corso case that we cited from the third DCA, if it's a wholly denied claim.
Mr. Monteverdi, so if we're to parse these cases, then I guess what you're saying is we need to look at the point in time immediately before suit was filed as to what the insurer's position was on the denial of the claim.
I actually would not even go that far because I think the Treasure K case dealt with that as well. And they said you can deny it for misrepresentation or concealment even after suit was filed, because that was the argument the insured made then.
Well, I guess I'm in this case, because, coverage was initially admitted. I guess what I'm saying is if we look at the facts as they evolved pre-suit, we should look at the point in time, what was the insurer's last position on the coverage issue? And here you're saying it was wholly denied and they've asked for the money back. So, and even though they've continued to say that, I guess I'm just looking at, because we have to look at, what were the facts between the parties and the circumstances prior to suit. We can't ignore what happened. But if we were to try to separate some of these cases, the distinguishing factor, I think what you're saying in Leeward that we were to look to is that at the time before suit was filed, the coverage was denied and it was deemed void. They had argued it was void.
Yes, and I can actually give a line, maybe I can come to a little bit of a line here that both you, Judge Smith, and Judge Morris have asked for, which is, let's say that, for instance, American Capital had gotten those 2018 roof replacement bids in 2018 and then received the Katerra estimate and then made an initial grant of coverage and paid. Then suit was filed and then tried to come back and said, oh, wait a second, now you're misrepresenting the claim. It's like, well, wait a second, you had all the information. Now you can't go back and say it was a material misrepresentation that impacted you because you had the information all along. But that's not what happened here. What happened here was that we got the sworn proof of loss. We went out and made a determination, got the sworn proof of loss, got the estimate, and then got the documents, and then took the EUO, and then determined, wait a second, what's going on here? And then later learned that the roofs were actually done. That's the most amazing part about this, is that we didn't even learn that until we took the deposition of the roofer. The association never told us that. We were in the midst of litigation and were shocked during the deposition to find out that the roofs are being replaced. But the claim was still $7.1 million for the roofs. And so ultimately it comes down to, okay, well, wait a second. Will a jury decide this is a misrepresentation and concealment that voids coverage under the policy pursuant to the terms of the contract? And we go back, we keep going back to the contract, and I'll go back there again. I'll go back to that well one more time.
Well, you need to stop now, so we're not going to get to that well.
Fair enough.
Thank you both very much. You can leave this virtual space by clicking the leave button in the lower right-hand corner of your Zoom window. And